Number 21, the matter of East Ramapo Central School District versus King. Good afternoon, Counsel.
Good afternoon, and may it please the court. My name is Randall Levine for appellant, the East Ramapo Central School District, the petitioner in this Article 78 proceeding. I'd like to reserve 2 minutes of time for rebuttal.
You may.
Thank you, Your Honor.
You're welcome.
The question on appeal is whether state law allows a school district to obtain judicial review in state court of the state education department's annual IDEA compliance determinations. SED argues that Article 78 review is barred by federal law, and as a result, its compliance determinations are completely immune from all judicial review, either in state or federal court. That result would
Counsel,
be...
I'm sorry to interrupt you, but you can call it right of private action under the federal statute, or you can call it a right to challenge under Article 78, but isn't it essentially the same analysis, which under our case law is, does the legislature want you to prohibit you from doing this? So what's interesting here is it's really the Congress, right, that's enacted this statute, and the state has a certain role in enforcing it and in carrying it out. So isn't the analysis really the same? It's under our law, does the legislature and here the Congress intend for or prohibit a right to challenge this type of action? And it seems if you look at the congressional scheme, the federal scheme, there are certain ways you can do that if you're a parent or if you're a school district. So whether you're calling it a right to private action or a right to bring an Article 78 proceeding, it seems to me just different ways of labeling the same analysis.
No, they are not the same analysis. In fact, they are not even similar. Article 78 provides an independent right to anyone aggrieved by agency action.
Well, unless the legislature intends otherwise.
Even if the legislature does intend otherwise, this court has held repeatedly that the legislature cannot abrogate all right to judicial review, that for a statute to be valid, there must be a means of obtaining judicial review. And in those earlier cases, this court has held that judicial review always must be available where an agency disregards the standards required by the statute or acts in a way that's contrary to the language of the statute or otherwise acts in a way that is abusive or discriminatory.
We do. There are always certain limitations that certainly we allow in terms of access to judicial review. There's standing, there's mootness, there's timeliness. So it's not an absolute right, and so it isn't. And here, in fact, the statute does provide for some judicial review in some circumstances, but doesn't explicitly provide for the right that you're seeking. So doesn't that tell us something?
That tells you that Article 78 is available. Actually, the way Article 78 works is it provides a right to judicial review when no other statute provides its own procedures for judicial review.
But doesn't there have to be some right first for, to me, Article 78 seems more like a procedural mechanism to obtain review which a party is otherwise entitled to. And so that entitlement, the way I see it, has to come from somewhere. It's not inherent in Article 78.
Yeah, and that's not correct. Article 78 creates both a right and a procedure. It creates a right to be free and not to be subjected to arbitrary, capricious, or legally erroneous actions by state agencies, and it provides a procedure to obtain judicial review to achieve that remedy.
Does a distinction have to be drawn between an administrative act and a regulatory act that's being reviewed?
That distinction is not one that appears in any of the cases. It's not in the statute. It's any agency action by which a party is aggrieved. They can have Article 78 review. They can have judicial review.
So was the school aggrieved here?
Yes.
How?
The state education department determined that the district had violated the IDEA and the related state laws and regulations by settling with the parents of students with disabilities, even though the IDEA and the related state laws and regulations explicitly authorized those settlements.
What was the consequence of that?
The consequence of that and to literally follow the department's order would mean that the district can't settle any IDEA disputes with parents at all.
The consequence is not the ultimate withholding of the funds, that where the state disagreed with the process that was employed?
Well, it may lead to that. The department, in its directive, threatened that it would withdraw federal funds and refuse to provide additional federal funds to the district.
So does the school district need to run that process out and get to the end?
No, there's no indication that it would need to wait to actually have the department deprive it of federal funds.
Doesn't Article 78 have an exhaustion requirement?
Article 78 has an exhaustion requirement, but there's no administrative review procedure
But
for this determination.
Once the district is fined, can't it appeal to the secretary?
In that narrow set of circumstances, which are not where we are here, it could appeal to the secretary.
That's my
but
question, is if we're not here yet, have you exhausted your administrative remedies?
There is no administrative remedy for these determinations. This determination, this finding that the district violated the IDEA, has real consequences for the district. And the district should be able to obtain judicial review to be relieved of those consequences because the department's order is irrational and it's inconsistent with the
The
statute.
consequence that you're referring to, counsel, would be that the district couldn't enter into any more settlements as it had been doing. Is that what you're saying?
No, what I'm saying is that to follow the department's order literally would require the district never to settle at all and to litigate all the way through due process hearings and all the way through appeals, all
Never
due
to
process
settle at
hearings.
all, or never to use the process that was determined by the state to be inappropriate?
Never to settle at all. I mean, that's one of the key points here that is worth re-emphasizing. What the department did was it applied all of the rules for district placements, all of the rules the CSE has to follow in placing children, to a settlement. But a settlement never results in the same kind of placement or the same kind of services that the CSE recommended because, by definition, it's an agreement. So if the district can be held to have violated the law by... Yes?
You could continue to negotiate with parents, but only use the scheme that allows that type of negotiation under the statute, right?
The state education department did not find at any point that the district violated any particular rule that applies to the settlement provisions in the IDEA. That is not what the department found. The department found that the results of those settlements violated other parts of the IDEA that apply to CSE placements. That's what's irrational about the department's order. But I'll just point out that the confusion generated by the department's order and the reason there's so much to discuss here is actually why the Article 78 review that we're seeking should be allowed. Because these are serious questions, and these have serious consequences for the district. And that's why it was wrong for the appellate division to focus on the question whether there's a private right of action under the IDEA when we're not seeking any relief under the IDEA. We're not bringing any claims under the IDEA.
So, all right, so Supreme Court ruled against you on the merits, right, under Article 78?
No, actually, the
Okay.
Supreme Court didn't consider the merits. Instead, the Supreme Court simply deferred to the department's conclusions. And the Supreme Court ruled that a few...
So you're saying the Supreme Court decision wasn't a merits determination?
The Supreme Court did not actually consider the merits of our petition. The Supreme Court characterized what it did as a ruling on the merits.
All
But
right. So for my purposes anyway, maybe not for yours, but for my purposes, it looks to me like they ruled on the merits, given what they said. So if they ruled on the merits, but then it went to the appellate division, and the appellate division did not rule on the merits. Instead, they didn't rule on that. They didn't make a determination that merits rule. Instead, they said they took a different path and a different analysis. So if you were successful, what would you want us to do?
the appropriate thing for this court to do, and in the ordinary course, would be to reverse the holding of the appellate division below and find that Article 78 review is available. And then because the appellate division didn't rule on the merits, this court should remit to the appellate division for consideration of those contentions. However, this court does have discretion to consider the merits if it chooses to do so. And if it does choose to do so, the court should find that the petition should be granted. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. Jeffrey Lang on behalf of respondents. Judge Garcia asked, isn't it the same analysis under federal laws as it is under state law? as to whether there is a federal right, an enforceable right in this case. And it's exactly the same analysis. And in fact, what happened here is that Congress didn't want judicial review generally of this type of intragovernmental dispute between the state and one of its subdivision school
Counsel, to
districts.
follow up on that point, and it seems the difference here to me is, I think that you can argue this is the same analysis, and our analysis in Dairy Lee and the other cases is does the legislature intend for there to be a private right of action? You can fool with what that means linguistically and say, does that standing, is it, not everyone has the right to challenge every agency action. So there is this intent by the legislature to limit Article 78 review that we would follow, according to Dairy Lee. But here we have a federal statute. And is there something in the state enactment of their roles and responsibilities that would give rise to this type of an Article 78 review, separate and apart from the federal statute?
No, because their case is premised entirely on the violation of their purported federal right under the statute. And in the parallel federal action that they brought in the Southern District of New York, the district court said there is no such enforceable right under the statute.
Let me come at Judge Garcia's question a different way. Is the state of New York free to turn down the federal funding?
Yes.
It doesn't have to comply with the regulations
That's
if it doesn't
true.
want the money, right? So this isn't a preemption case, really, is it?
I wouldn't say it's not so much that it's preemption.
So
it's
I'm
that-
going to ask you this. If the state of New York did that, would there be an Article 78 action available here? If the state said, we don't want the money, we're not going to comply with your federal regulations.
Well, if the state violated some of...
It's free to say, I don't want the money, right?
Yes.
And if it said that, it can promote its own regulations. They could be the same as the federal. They could be different. And there'd be an Article 78 proceeding, no?
Yes, because that would be outside the framework of the IDEA, and there could be, yes, it could.
And so it's the state's decision to take the money that eliminates Article 78.
It is the state's enforcement action, decision to take the money and enforce the statute. In other words, uphold its end of the bargain. It receives federal money that ultimately go to the school districts, and in exchange, it has an obligation under the federal statute to implement all of the statutory procedures. And so if it takes an enforcement action against a school district within that framework, and the challenge revolves around a purported right under the federal statute, then there is no Article 78
All right,
review.
So then what, if any, is the district's recourse?
Well, I mean, the only real administrative sanction under the statute is the withholding of money. And if the state withholds money, then the district has a right to a hearing and to take an appeal to the U.S. Secretary of Education. And then if there were to be a lawsuit after that, the school district could always sue the Secretary of Education under the Federal Administrative Procedures Act.
But short of denying money. This complaint now, that
Sure.
they say the state has misinterpreted the statute, right? That's their argument right now.
Yeah, they
And
have.
we are suffering a consequence, a real consequence, as a result of that misinterpretation. You're saying, well, you can't pursue that in state court in Article 78. So what, short of waiting for the action where the money is not trickling down to them, what recourse, if any, maybe you don't think they have any, what recourse, if any, do they have for this claimed misinterpretation of the federal statute?
Well, they have a couple. One is that the Secretary's Office of Special Education Programs responds to inquiries concerning the meaning of the statute and the Secretary's regulations. And there are a number of responses. This is as we cited in our brief, on the U.S. Department of Education website. So if they have a question about the meaning of the statute and they think that the state is misinterpreting the statute, they can proceed that way.
And what happens in the interim?
Well,
I think you might concede, that might take some time.
it could, and in the interim, the state would only withhold money in the very last resort, and we try to work collaboratively with school districts to remedy problems. So I mean, in the interim, the state would expect the school districts to correct the issue.
Go ahead, go ahead. I just
I-
did-
the-
finish the
the-
second
the
one.
second, I mean, the second avenue that a school district would have would simply be to, even outside, a written inquiry would be to approach the U.S. Department of Education informally and, complain that the state is misinterpreting the law. And the one thing I do want to make clear is that the state isn't operating in a vacuum here. Just like the state monitors local implementation, the Secretary of Education monitors very closely state implementation, and there's an annual review.
What is the meaning of the federal district court's dismissal of the action? How do you interpret that? Does that support your position or not?
Well, it supports our position because it says that the district is trying to vindicate a federal right, and the federal court has said there is no such right. So if there's no such federal right, you can't proceed under the federal statute directly.
So that decision would be consistent with the third department decision?
It's absolutely consistent with the third department decision. I mean, I would say that the third department decision is consistent with a line of cases in the third, fourth, and first departments where parties tried to assert purported federal rights under the federal statute. In a couple of those, it was the Medicaid Act. And the court said, well, there is no enforceable, judicially enforceable right under those federal statutes, so you can't proceed indirectly. You can't
Well, they
bring an
use the
enforceable.
private cause of action language that Judge Garcia referred to before.
Right. I mean, there was no private cause of action, so you couldn't proceed indirectly under Article 78 because you just don't have an enforceable claim. And those weren't.
Under our regs, there's a provision, NYCRR 200.5 subdivision 1, that provides for the right to file a complaint claiming that either a school district or state education department has violated state or federal law regarding educational students with disabilities, right? Educating students with. So who does that apply to? Who has a right to file a claim under that regulation? It doesn't specify.
No, anyone can file a claim, but if the claim concerns the treatment of an individual child, then you go through the due process procedures that the statute provides for a parent to contest.
I understand that, but isn't this something different, or is that what this pertains to?
No, it's something different, but what I'm saying is that the regulation specifically says that if the administrative complaint pertains to an individual child, then you have the right to a hearing and you follow the due process procedures that.
But who, can you give me an example of what, or who, whether it's an organization or an individual, or who would be able to file such a complaint?
Oh, an individual, a parent, the school district can file.
And is it your argument, counsel, that this litigation is focused not on an individual child's needs being satisfied appropriately by the school district, but rather on the process that's being employed?
Yes, that's precisely our argument, because a number of the federal courts looked at the statutory scheme and they said that the Congress had one express provision for a lawsuit, and that had to do with the treatment of an individual child. And this also goes to our standing argument, which is that the school districts are just outside the zone of interest protected and promoted by the statute. Congress wanted to protect parents and individual children with disabilities, not the financial interests of school district. I just want to make one quick point about the settlement. Nothing that the state ordered made it impossible for the school district to enter into settlements. We just didn't want them doing it without adequate support. In fact, the school district has, since this directive, we know, entered into settlements, and they've been found in compliance. So it's just incorrect that we have prevented them from entering into any type of.
Chief
Thank
Judge,
you,
I'm
sir.
sorry, one
Yes, of
question.
course.
When can the school district go to the Secretary of Education?
If the state withholds or reduces money at all, and then there's a decision to do so, there's an appeal to the Secretary of Education in that case, and that's the formal administrative procedure.
But
And then
triggered by the withholding of funds?
Triggered by
specifically?
triggered by the decision to withhold money.
Thank you.
Counsel?
Thank you. Just a few points. The State Education Department argues that the only possible way for the district to obtain relief would be to go to the U.S. Secretary of Education with this challenge. If that was a possibility, we would be there, because the U.S. Secretary of Education agrees with us on every single one of the points in
That's because no funds have
contention.
been withheld, or it hasn't been determined that funds will be withheld, so you haven't gotten to that point. Isn't that why?
Yes, that's correct.
So what's the harm to you then, as you stand here today?
Well, the harm is that the State Education Department found the district to be in violation of the IDEA for settling complaints, as we're authorized to do under the IDEA.
That's what they found. What is the harm?
Right. That harm, well, there's two pieces. One is the harm that of the preventing the district from being able to settle, and apparently there's a difference over what the order actually requires. That's another good reason why Article 78 review should be available.
I hate to be repetitive, but preventing them from settling, that's not a harm. What is the harm that results from being prevented from settling?
Oh, it requires the district
in fact you
it
are.
requires the district to litigate due process complaints that it prefers to settle. That costs money.
Or does it just require the district to document the basis for the particular settlement reached under the principles of the IDEA?
That's not what the department's order says, and that's certainly not what the law says. There's no requirement in any regulation or in any statute that requires the district to document the
How are you settling
reasons.
cases differently now than you were before this finding?
I'm not aware that that's not in the record, and that's not something that I've been part of.
Well, doesn't the order actually say you can settle cases as long as you do it the following ways? It doesn't say you can't settle.
It doesn't say as long as you do it the following ways. It says you can't settle by having a single district representative overrule the CSE.
Right,
But,
so you could have 2 district representatives, or 5, or 7, right?
well, that, first of all, to find that that would violate the IDEA would be arbitrary, because there's no requirement in the
We're asking about
IDEA
whether
or
it's
any
right or
other rule.
wrong. We're asking
But-
about whether the terms of the order prevent you absolutely from entering into any kind of settlement.
Right. If the order says that the district can't overrule the
Not if it
CSE.
says, what does it say?
Right, it says the district can't overrule the CSE by agreeing to a parent's requested placement in a settlement. But that describes every single settlement. So if the district can't agree with a parent to an alternative settlement, an alternative placement, it can't settle at all. That's why the order that the department gave is so difficult for the district and imposes such a burden on the district. There were also administrative burdens that were more minor, but those too give the district standing and a reason to be aggrieved and to seek Article 78 review. Thank you.
Thank you, counsel.